Governor Evers, the Wisconsin Elections Commission, and 6 liberal-leaning voting organizations are criticizing the legal argument Madison and its former clerk are making in an effort to dismiss a case over lost ballots. The lawsuit is over the 193 absentee ballots that went uncounted in the 2024 November election. The city claims that case should be thrown out because the right to vote by absentee ballot is a, quote, privilege, not a right. Evers and the WEC filed a brief pushing back on that, saying it could set a dangerous precedent. I sat down with Madison Mayor Sati Rhodes Conway to break down the city's legal argument. I kind of want to get started by asking why the city is looking to dismiss this case.
I want to start with the city is so committed to voting and to absentee voting in particular. Now, the question of this lawsuit, right? So we went through a whole process with the Wisconsin Elections Commission where we fully cooperated with their investigation, and they wrote an order and telling us a whole bunch of things that we needed to do. We have done all of those things. In fact, we have done more than that to make sure that our processes are safe and secure. We are very sorry for that mistake, and we have improved greatly. So this lawsuit is not about making us improve. The only thing that this lawsuit is about whether or not clerks in the state of Wisconsin, when they make a human error, should have to pay up to millions of dollars for those errors. That's what this lawsuit is about. And that's why we would think it should be dismissed, because I think it is a terrible precedent if clerks around the state know that they can get sued and have to pay millions of dollars if they make a human error.
Should these voters be able to be compensated for their ballot being uncounted?
No, I don't think so. I think what the voters deserve and what they have gotten from us is an apology, and the fact that we have worked to make sure that that will never happen again.
I want to move now to the argument at the center of the controversy here, because the argument listed in the brief reads, when the absentee process unfortunately results in a vote not being counted, it is not a violation of a constitutional right. Is voting absentee voting not a constitutional right?
Well, so what we're referring to there is something that's in state law that the legislature passed in 1985 and is still on the books. And if you look into the legal documents, what they're quoting is a state law, right? The state law literally says that absentee voting is not protected in the same way that voting at a polling place is. So when I quote the state law, it doesn't mean I agree with it, right? When a lawyer quotes the state law, it doesn't mean that lawyer agrees with it. It means that that's what the state law says. So personally, I think that every form of voting is a right and that every ballot should be counted regardless of how it's cast. What I think, though, people have a problem with is not us or this lawsuit, it's with the state law. So if the state law is suggesting that absentee ballots are not as protected as other ballots, then we should change the law, right? We should fix that, because that's a huge and very concerning loophole.
But the city of Madison is the ones using this argument. Does it set a dangerous precedent? Because that's some of the concerns we've heard. Like, for example, we heard the chair of the Wisconsin Elections Commission writing, unquote, for the first time ever, the Wisconsin Election Commission filed a friend of the brief court. Why? Because the city of Madison was essentially arguing they didn't have to count absentee ballots, which is preposterous. She then continues by saying,
I just want to interrupt you, because that's not what we're saying. We are not saying that we shouldn't have to count absentee ballots. No one is saying that. I think everyone agrees that absentee ballots need to be counted and that absentee ballots are just as valid as every other ballot. Everyone agrees on that. What we are saying is that we should not have to pay up to millions of dollars if someone in a clerk's office makes a human error.
Yes, but the question is, from both the WEC and the governor, and we've seen a bunch of people weigh in on this, that this could set a dangerous precedent. Do you think that that could happen?
I think there's room for lots of dangerous precedent in this lawsuit. I think it is an incredibly dangerous precedent to say that clerks' offices can be sued and have to pay lots and lots of money that right now is going to provide basic services, money that could go to pay poll workers better, money that could go to secure our elections. And there is no clerk's office in this state that has adequate funding, right? And the precedent of having clerks have to pay money if they make mistakes, I think is incredibly dangerous for our state. Is it also dangerous to set a precedent if the court should decide that absentee ballots are not protected? Yes, of course. But the only reason that we're between these two precedents is this lawsuit. No one disagrees that absentee ballots should be counted and should be protected. There is no disagreement there.
Why use this argument?
What would you ask us to do if I, as an elected official who has a fiduciary duty to take care of the city budget, do you think I should leave an argument on the table that might mean that I can save my municipality millions of dollars that we don't have, that we couldn't spend because of expenditure restraint limits from the state? Right? Because of this lawsuit, we have to use every possible argument to defend ourselves and to not have to pay out millions of dollars.
And you feel like this is the best avenue to do that?
No, I don't feel like it's the best avenue. I feel like we are left no choice. I feel like this lawsuit is putting the entire state between a rock and a hard place. And I think there's, whatever the court does, I think that there is danger of really bad precedent here.
We're seeing voting underway right now for the February 17th primary. For voters going out who are seeing the headlines from this and the argument that's in the brief, I understand what you're saying, but the argument that's in the brief, what would you say to those voters who are a little bit concerned? How are you trying to gain their trust and maintain trust of voters in Madison?
Well, I would say, first of all, that you should choose the method of voting that works for you. Right? You have lots of options to vote in the city of Madison. You have more options in Madison than you do in many other communities across the state. So if you feel most comfortable voting on Election Day, you should do that at your polling place, absolutely. If you would like to take advantage of one of the many sites that we have for early in-person voting, go to one of our libraries. You can come right over here to the municipal building. There's lots of options to vote early if that is the thing that's going to be best for you. And if it works best for you to vote absentee, I can guarantee you that our processes have improved, and that is a safe way to vote.
We also saw the governor put a statement out about this. Have you spoken with him or any other top officials about this?
I haven't talked to the governor about this, but again, I don't think there's any disagreement. I don't think that the governor and I disagree on this. I don't think that the Elections Commission and I disagree on this. In fact, I don't want to speak for Law Forward, but I don't think that we disagree with them on the question of whether absentee voting should be safe and secure and every absentee ballot should be counted.
Thanks for taking the time to chat with us.
Thank you.